I'm going to turn now to ground A in the notice of appeal and the various sub-iterations of that developed in the grounds of appeal. This raises several interwoven issues. It raises the question of whether the underlying claim is the right type of claim, i.e. is it vested in the company, not the claimant, so that it would be barred otherwise by the rule in Foss and Harbottle. Secondly, is the derivative claim being brought for the benefit of the company? Thirdly, is it being brought for the right reasons, i.e. not with an ulterior motive? Fourthly, does the claimant have sufficient interest? And it also raises the question of whether there is an alternative remedy. And the need for there, what I say is the need for there to be reflective loss as between the claimants and company arises from these requirements, these issues. First, because if there isn't a reflective loss of some sort, then the claim is unlikely to be barred by the rule in Foss and Harbottle, the underlying claim. So it won't be a derivative claim at all. Further, if the claimants are seeking to make good such a loss to the company, then it will usually follow that the claim will be for the benefit of the company. And if they aren't seeking to make good a loss that they and the company have shared, if one likes, then it won't usually be for the benefit of the company. And thirdly, and particularly in this case, it will ensure an identity of interest between the company and the claimant. And that is particularly important in a case such as this, where those who stand in a similar position to the claimants, other members of the scheme, have widely varying interests. And this is a point the court has touched upon, but if I can ask the court to look at the judgment, which is tab 16, page 170, which is where the figures themselves appear. It can be seen, paragraph 4, 200,000 active members, 188 deferreds, 90,000 pensioners. So deferreds are people who've left active service but haven't started taking their pension. So, and 1,000 child pensioners. So broadly speaking, 200,000 people who are still accruing benefits affected by the benefit changes, and 280,000 people who are not accruing benefits and are not affected directly by the changes to benefits. And Professor Davies himself accepts that not all members of the scheme have the same interests, and that it's self-evident really, but it's worth looking at his statement. It is in Supplementary Bundle 1, tab 2, page 19, or rather perhaps page 18, where he says the claimant's acknowledged company must balance varying interests of scheme members, and then at A and B he notes that retired members have different interests to the active members of the scheme. We'd say, in fact, it's more than that, because deferred members don't have an interest that's shared with the active members. And so if the loss was consistent with the loss to the company, it would be easier to show that everyone had an interest in the same outcome. That's not the case here. Now,
although it might be in relation to, I'm just thinking about, for example, of course, I'm saying there are all sorts of categories of beneficiaries with different interests. That is a problem which is most stark in relation to Claim 1, but when you come to 3 and 4, costs and fossil fuels, you could see that perhaps that affected the membership as a whole.
Yes, I mean, for example, if you had a case where there was bad investment advice, so the scheme lost lots of money, and again, we're blurring the lines between the company and the scheme, but insofar as that was appropriate, or if the company had suffered a loss as a result, then it's one thing if everyone has suffered the same thing, and if everyone has not, that's a good reason for it not to be a derivative claim. That is why, in my submission, reflective loss is necessary.
And in this case also, there may be said to be, I'm not an actuary, it may be said to be that there is benefit, actual benefit to the deferred and the pensioner members in increasing the level of prudence, etc.,
Yes.
which leads to the benefit changes which are detrimental to other groups. And so there is a real tension there.
There is, my lady, yes. Now I'm going to deal, I hope quite shortly, with the cases on common law claims, and many of these my learned friend went to yesterday, and these are in the core bundle of authorities.
Right.
Yep. And the first authority I'll go to is Daniels and Daniels, 1975 decision, Mr. Justice Templeman as he was, which is behind tab 4. And there's a background. Seems to have been a family dispute being carried on through the means of the company, but at page 42 of the bundle, and that's page 408 of the report, at F, Mr. Justice Templeman sets out the reference to Foss and Harbottle, and then says that there are exceptions, and then dealing with the fourth exception, that's 5 lines up from the bottom. Fourthly, if there is fraud and no other remedy, must be a minority who are prevented from remedying the fraud or taking any proceedings because of the protection given to the fraudulent shareholders or directors by virtue of the majority. But I rely on the reference to there being no other remedy there. And then turning forwards to page 47 of the bundle, page 313 of the report, he deals at the bottom, this is at H, authorities deal with simple fraud on the one hand, gross negligence on the other, do not cover the situation which arises where without fraud directors and majority shareholders are guilty of breach of duty to the company, and that breach not only harms the company but benefits the directors. And he then develops the analysis which along the lines that shareholders have to put up if the directors are an amiable set of lunatics, but not if their lunacy or negligence profits themselves. And this is the basis, starting point for the requirement, starting point of the authorities, between D and E. Says that there's the exception is that a minority shareholder has no other remedy, again, no other remedy, may sue where directors use their power intentionally or unintentionally, fraudulently or negligently, in a manner which benefits themselves at the expense of the company. And that's adopted as an accurate statement later on in microfusion.
But you can see from the facts of that case that it was perilously close to fraud in the sense that the fact that it had been sold to the wife for £4,250, and less than 4 years later it's sold on for 120,000.
Yes.
Does rather suggest as if there was some skullduggery going on.
It does. But the important thing is there must be a benefit, you know, even in the absence of fraud. Now, the next authority is prudential, behind tab 5, and this deals with a number of issues, some of them in relation to ground C and prima facie case, but I'll deal with all of the references in one go so we don't have to come back to it.
The thing to note about this case is what is said at the very, very beginning of the judgment. I remember somebody telling me that they took it in turns to read out the judgment.
Yeah.
I think they took a day.
More than a day.
More than a day, I think. It certainly took a day anyway to read out the judgment.
I think it's apparent early on which way it's going.
I think you're probably right, Mr. Chancellor.
The passages I rely upon in particular, at page 56 of the bundle, that's at page 210 of the judgment. Between D and E, there's a reference to the rule in Foss and Harbottle, a derivative action is an exception to the elementary principle. Then for E's, at the bottom of the page, there's a reference to Edwards and Halliwell. I'm not going to go to Edwards and Halliwell separately, it is in the bundle, but it's set out fully here. And at the top of page 211, it says there is an exception to the rule where what has been done amounts to fraud. Wrongdoers are themselves in control of the company. In this case, the rule is relaxed in favour of the aggrieved minority, who are allowed to bring a minority shareholders action on behalf of themselves and all others. The reason for this is that if they were denied that right, their grievance could never reach the court, because the wrongdoers themselves, being in control, would not allow the company to sue. And that, I say, is relevant to the alternative remedy point. And it really doesn't matter if an alternative remedy means that one of the requirements for a derivative claim, i.e. wrongdoer control, isn't met, or if it's a separate bar, because that slightly begs the question of what sort of wrongdoer control. The wrongdoer may be completely in control of the company, but in this case, for example, they're not in control of whether anyone brings a discrimination claim. So if that's the grievance, that's the dispute, that dispute can be litigated irrespective of the constitution of the board. Briefly, turning on to page 65 of the bundle.
I'll just leave that one go for a second. I'm not going to pick you up on it, but just to be clear, I don't think that statement in Prudential and Newman quite reflects the extension in Daniels and Daniels, does it? The exception to the rule is where what's been done amounts to fraud. It's fraud or self-serving negligence, isn't it?
Yeah, yes.
Yeah. Sorry, page 65.
Page 65 is, as with many of these cases, they don't all set out every element. They set out the key elements that are in issue in that case. But at 65, F to H, the court is dealing with how to deal with such claims and raises the issue that on the one hand, if you require the plaintiff to prove fraud and control before he can prosecute the action, then you might need to fight the action to a conclusion before you decide if it's brought, which is not appropriate. But then at over the page at 220, missed my reference. The gist, I say, is between F and G, is it's made clear that it would be wrong either to require the claim to be fought to a conclusion, but also between F and G, if upon such an application the plaintiff can require the court to assume as a fact every allegation in the statement of claim, as in a true demurrer, the plaintiff will frequently be able to outmanoeuvre the primary purpose of the rule in Foss and Harbottle by alleging fraud and control. So pausing there, prudential is authoritative, that they say that's not the correct approach, and you should not, or one should not, assume every allegation made by the claimant is true, as you may do in, or as may be done in other types of hearing. At page 67, between G and H, the court at G rejects the idea that there's an exception to the rule in Foss and Harbottle whenever the justice of the case so requires. Say there shouldn't be a full dress trial before the test is applied. On the other hand, we do not think the right to bring a derivative action should be decided as a preliminary issue upon the hypothesis that all the allegations in the statement of claim for control of facts, as they would be on the trial of a preliminary point of law. And they go on to say, in our view, whatever may be the properly defined boundaries of the exception, the plaintiff ought at least to be required before proceeding with his action to establish a prima facie case. One, that the company is entitled to the relief claimed. Two, that the action falls within the proper boundaries of the exception to the rule in Foss and Harbottle. And that's where the reference to prima facie case is found, which is adopted later in Waddington, Aberaya and Buller. And then finally, at page 70, and in passing between G and E, this is at page 224 of the report, it was suggested that the court should give judicial approval to the public spirit of the plaintiffs who are pioneering a method of controlling companies in the public interest without involving regulation by a statutory body, and the court says that's really a matter for Parliament or the city. So it's no answer here for the claimants to say, well, we just want to make sure the duties are complied with. The derivative claim isn't there to allow well-meaning bystanders to enforce duties. It's there to recover loss in the interests of the company. Just pausing there for a moment, I recall yesterday the court said, I think my Lord Justice Snowden said, that at the second stage of a statutory claim, prima facie test is no longer relevant. I'm not taking issue with that, but I'm just observing that the White Book, without any authority, says that is the test. So that may be, it's at note 19.15.6, but as I say, that's not relevant to us here, and I'm not suggesting the White Book is right. In fact, rather the contrary, but that's where the impression may sometimes have been given that that was the test at the statutory, in a statutory case. Now, in some ways, that may be something of a side issue, but if there isn't a prima facie case on the merits, then it's very difficult to imagine permission being given in any case. If there is a prima facie case on the merits in a statutory claim, permission may still not be given because there might be a good case on the merits, but it will be really expensive and will produce very little money. So there's more to the test, but prima facie case is probably part of the test, even in a statutory case. But that's by the by. I'm certainly not.
It may be, as in a sense, as I understand it, what I suppose it might be saying, and I don't have a white book with me, you have to show, if you're a claimant, a prima facie case to get through the paper phase, when, at least as I understand it on the statutory scheme, there will only be you ordinarily putting your case forward on paper if you're the claimant. The judge may form the view you have a prima facie case and then convenes an inter-parties hearing. At the inter-parties hearing, of course, it may be that the defendants would say, actually, there wasn't even a prima facie case.
Yes.
And they may seek to, as it were, it's a tough call because if prima facie case means first glance, you know, it's either
Yes.
at first glance or not. But they may, for example, say that there'd been a misrepresentation of the position by the claimant on the papers or whatever. So I can see that a prima facie case may come into it, but is in a sense in reverse. But the actual issues that are then in play, as you say, are actually much broader on the statutory
Yes.
at the second inter-party stage, because the fundamental question there is whether independent director acting in accordance with his statutory duties would consider it appropriate in the interest of the company to carry the claim forward. Generally speaking, that in particular is said to be, I think, what is the court has regard to have regard to.
My lord, yeah, and one of the things such a board would have regard to is the merits.
Yeah.
So if the merits are
Yeah,
poor, it's
beyond the
probably
prima facie but poor,
Yes.
or as opposed to very strong.
Yes.
Yeah, absolutely.
So, my lord, moving on to Barrett and Duckett, which I think your lordships, your ladyship were taken to yesterday. That's at tab 10, and it's at page 206 of the authorities, and it's paragraph 212 that I rely upon. I think you were shown this, but I think you want to make my own, emphasise particular points. Paragraph.
Page 212.
212.
Yeah, in fact, 230. Well, 212, which is at page 249 of the authority. The general principles are set out, although said not to have been in dispute. So this was on the ground rather than argument. But at 4, where a challenge is made by a shareholder, a challenge is made to the right claim by a shareholder to bring a derivative action on behalf of the company, it's duty of the court to decide as a preliminary issue the question whether or not the plaintiff should be allowed to sue in that capacity. And at 5, in taking that decision, it's not enough for the court to say there is no plain and obvious case for striking out. It's for the shareholder to establish to the satisfaction of the court he should be allowed to sue on behalf of the company. Pausing there, that does go back to what was said in Prudential about it was for the prospective claimant to show things. And then at 6, shareholder will be allowed to sue on behalf of the company if he's bringing the action bona fide for the benefit of the company for wrongs to the company for which no other remedy is available. And again, I rely on the reference to there being no other remedy.
Well, it's you have to look at the first bit. The whole purpose of a corporate derivative action is because the company has been wronged. To go back to Lord Denning and Lord Steiner, ask yourself the question, who is damnified here?
Yes.
And if the company is damnified, but because of wrongdoer control, the injustice would not go remedied,
Yes.
you give a shareholder the opportunity to bring the claim.
Yes.
It's the company's claim, but he acts as agent of the company. He's appointed by law, if you like, to act as the agent of the company. That's Lord Denning's pithy summary.
Yes.
So it is important to understand who's wrong, who has been wronged,
Yes.
because it's only unjust for the company not to be able to sue if it's the company that's being wronged.
My lord, yes.
And in a sense, a lot of the questioning I think that we were putting to Mr. Grant, certainly I was anyway, was directed at the question of who has actually suffered the alleged loss here, and that knocked on into the question of whose would hold any recoveries.
Yes.
Sorry, who would benefit from the recoveries? Would they be held by the company beneficially, or would they be held by the company for the trust? It seems to, it is important, as I see it, to identify who the wronged party is when you're asking the question, is it right to allow a derivative claim to go forward of any sort?
Yes, my lord. Indeed, and that is part of our case, and it also explains the utility of reflective loss, because if the company has been damnified and has suffered a loss, then it has the right of action, and a prospective claimant seeking to make good that loss for the benefit of the company has a derivative common law claim.
The difficulty is reflective loss is used, a term is used for two different purposes.
Yes.
And I personally find it an unhelpful focus.
Yes, my lord. That I'm using it in a pre-Marex sense, which I appreciate. It also, I must say, my learned junior winced every time I've said reflective loss. I think for exactly the same reason. But these cases were decided.
Sore point, Mr. Shaw.
My lord, yes. Well, I mean, the Supreme Court changed its mind. But there we are. But there must be the same type of loss. If the company has suffered a loss and it's something consistent with that, even if it's not a reduction in shareholder value, but something that flows.
Normally, the way this expression was first used was to say, if the loss of the shareholder is simply reflective of the fact that the company has suffered loss, the shareholder cannot sue.
Yes.
Because his only, we saw this in Prudential, in fact we didn't see it in Prudential, but it's very clearly set out in Prudential. If the only loss allegedly suffered by the shareholder is that the value of his shares has been diminished proportionately by the fact that the company has suffered loss, in other words, his personal loss is simply reflective of the company's loss, he can't sue. That's
Yes.
I'm not sure that's the way in which that expression has been used throughout the authorities. And certainly in this case, seems to be being used in a different sense.
My lord, it is, and it is unhelpful that it's used in a different context in a very specific way. I'm not suggesting there has to be a reduction in shareholder value.
No, I think what you're saying, sorry, as I understand it, I think is, well, anyway, no, go on, I'll let you
But
say what I think.
does it come to this? So let's leave out the word reflective. That what has to be shown is that the company has suffered a loss. The company has been damnified, as my lord says.
Yes.
And that has also been causative of a loss to the claimant.
Yes, and slightly more than but for causation.
Yeah.
It must be a consistent loss. So taking away
where do we get that consistent gloss, if I can put it that way?
But that, in my submission, is what is being. That's the sense in which reflective loss is used.
But you see, the whole point is, where you have a company case, a shareholder can sue because the shareholder has a proportionate, well, he has a bundle of rights.
Yes.
Which there's a passage in Prudential somewhere, somebody hope can find it, but where they explain that the shareholder, by reason of holding shares, has a series of rights against the company which allow him to participate in the company on the terms of the articles. And in a sense, you never have to ask the question, therefore, whether a shareholder is interested in the company pursuing a cause of action for loss to the company. In a sense, he always is, because he's a shareholder. Or at least, there is an established relationship.
Yeah.
Difficulty I have, in some way, he will have suffered a loss inevitably in that context.
Yeah. If the company is solvent, he's inevitably harmed in his capacity as shareholder because of the nature of the rights that are shared.
And that loss, force, or damage to him or her as a shareholder is concomitant, if that's another word, like use of the word consistent. It is the same nature of loss or damage suffered because the shareholder holds a bundle of rights which amount to, in unlegal terms, a share of the company.
Yes, that is the simple and most straightforward example.
Yeah, and also he has precisely the same proportionate interest as every other holder of the same class of shares.
Yes.
So you never actually need to go into the minutiae of whether his, quote, interest is the same as the company. You know it's a derivative of the company.
Yes.
But where there is a difference, as I see it, with the beneficiary and trustee situation, is that the beneficiary has his rights under the trust instrument, and they may, but may not be, the same as other beneficiaries, depending on the nature of the trust.
Yes.
So you have to actually look at that question when you're answering the question of whether he is an appropriate person to assume the role of claimant trustee.
Yes. I don't dissent from that, and that is ordinarily how one can be sure that the claim is being brought for the interests of the company. It's not always the only question. In some cases, permission has been refused, where someone does have a shareholding, but they're bringing it for an ulterior reason, either to continue a family dispute or to improve their position as a creditor. But perhaps if I can deal with it by way of an example, prior to the statutory claims, it would, in my submission, have been possible for a derivative, common law derivative claim to be brought in relation to a company limited by guarantee in, for example, a housing development, which I understand is a common use for companies limited by guarantee because of the leaseholder right to manage legislation. And in that case, I think there's a mistake in our skeleton of paragraph 31 where we refer to every leaseholder, every tenant having a share. In fact, every leaseholder is made a member of the company. And in that case, let us say the board of directors is misappropriating building materials or buying them at overvalue to benefit themselves. There would be no reflective loss in the sense of a reduction in shareholder value. But in my submission, that would be the type of case where the loss is consistent or concomitant with the loss of the company, because the company has lost goods or overpaid, and the individual leaseholders are going to have to pay more money.
Yeah, it's going to, the service charges are going to go up.
Yes.
Because
so even though it's not
siphoning off money.
My lord, exactly. So even though it wasn't a reflective loss in the Marek sense, it would be a sufficient, consistent loss to ensure everyone has the same interest, claims being brought on behalf of the company and for proper reasons. Now, Waddington, which is at tab 11, page 230, well, the extract I want to go to in fact is at page 229. Usually this authority is referred to for what Lord Millett says, paragraph 33 onwards. But here Mr. Justice Ribeiro deals with the prima facie case point, paragraph 13 onwards, and 13, 14, 15, 16 deals with the 17 deals with the English authorities, 18 and 19 deals with some decisions from Hong Kong. Then at 20, his conclusion is that the common law rule is therefore that a plaintiff whose standing to bring a derivative action is challenged must establish a prima facie case. Going down, whereas often occurs, plaintiff seeks in order to be indemnified for costs which may benefit from the derivative action. The court's approach is to consider whether and to what extent an honest, independent and prudent board might decide to authorise prosecution of the action given the available evidence. So that's, in my submission, what a helpful guide, also what Mr. Justice Leech did here. Lord Millett's.
And just out of interest, we didn't. In a corporate sense, what Mr. Justice Ribeiro says at 13 is accurate, isn't it? Namely that a common law, in fact 13 and 14, at common law before the statutory requirement was introduced in relation to that which is now CPR 19.14. There was no requirement to seek permission to continue the claim or even to bring it. Yes. You basically titled your action, Snooks, in right of the company, yes, as a minority shareholder in the company, and you joined the company and the respondents. Yes. And it was for them, as he says at 14, to try and strike you out on the basis that you didn't have a personal cause of action and you shouldn't be allowed to bring it derivatively.
Yes, but the test applied at that stage wasn't the ordinary striking out test, i.e. let's assume everything's true in the claim, correct, see if it's bad in law. There was a burden at that stage on the prospective claimant that they should be allowed to proceed.
But bearing in mind that in the current case, as I understand it, it's common ground that we are not in the CPR 19.14 framework.
Yes.
We are not in the framework of a member of the company bringing proceedings at common law, such as a double derivative or indeed more multiple derivative claims in the company law sense.
Well, my lord, we are in that position because that's the claim that has been brought.
There are two separate points here, aren't they? That where there is a what might probably be described as a double derivative or multiple derivative claim, is to say where you've got a parent and a subsidiary company, one shareholder in the parent who wants to bring a claim in respect of a loss suffered by the subsidiary, then I forget which case of Lord Justice David Richards as it is now, but in one of his decisions he says that the procedure in CPR 1915, as it now is, applies by analogy.
Yes,
right.
It's a later Boston Trust. But this is not a case of a shareholder in a parent company. This is a different sort of creature, or however we describe it. It's a completely different sort of creature. So I think one of the points that troubles me is what on earth is the basis for saying that we go through the same procedure in the present case?
Well, my lord, I say the basis for it is that this is brought as a common law corporate claim for the reasons I sought to express before lunch.
Yeah.
And the basis for
I disagree.
well,
that's how it's been framed.
That's how it's been framed.
But as we said from the very outset of the hearing, I mean, I think my lord thinks, and I certainly think, it's unsustainable on that basis.
Well,
But sorry to interrupt and to interrupt Your Lordship, but that is how it's brought, and I think the question which we are all posing in different ways, which comes out of what you're saying, is if this is a common law multiple derivative action, which isn't in the normal frame, so we haven't got a string of companies and we can see up and down that string somebody as a shareholder of someone else, and we can apply the vanilla test but elongated. In those circumstances, how does one judge the standing of the person? And it's easy when they're a shareholder, and we've discussed why it's easy. But how do you get over that hurdle when it's not easy, when you've got to apply the tests that we've looked at in the authorities? And that's really where we are. And how do you apply that in circumstances so that we know what the parameters are of the test?
And you very helpfully said a moment ago, in the context of the members of a property owning company in a block of flats or whatever. I mean, in Stamco, they were actually shareholders, but they could have been members of a company limited by guarantee, and you could have had the same factual scenario. And I would be very surprised if Sir Robert McGaughey hadn't reached the same conclusion as he reached, on the basis that they were members and therefore had a sufficient interest. But beyond that, I mean, it's very difficult to conceive of that type of case in terms of a double derivative or multiple derivative case, because it just doesn't sort of stack up, at least in my mind it doesn't. But I mean, we're not even in that situation. We're in a completely different situation where there's only one company, but these people are not actually, these claimants are not members of it, they're not shareholders of it.
yes.
They are actually members of and beneficiaries of the underlying or the overlying trust.
Yes. And
I mean, what I'm sort of, and following on from what was just said, I'm sorry, I disagree, intervention was probably a little brusque. Let me try it again and explain why I'm positive. I have as much connection to the company in the corporate sense as the claimants do.
yes.
Because neither of us is a shareholder, neither of us is a director, or neither of us is a member. There are no shareholders, there are members, and we're not directors either. They are the same, in fact, in relation to this company. What they have, which prevents them from being mere busybodies, I think, to use a sort of
Yes.
administrative law term, wanting to take on a claim on behalf of a company, is that they have the capacity and the interest of being a beneficiary of the trust which is administered by the company. That's their interest. I think it was accepted, that is the thing which connects them to the company. But it's the interest as beneficiary under the trust, and I'm puzzled why you choose to engage, I know, with the claim in the way that it's formulated, with the application of all the company law doctrines, some of which are completely inappropriate, when the doctrine which stares you in the face as a trustee and a beneficiary is what I would call, and I think you did as well, the beneficiary derivative claim. I know we're going into company law, and don't get me wrong, I love looking at company law cases, but I just don't see at the moment why you choose to fight this case on turf which has principles at play which just you cannot reflect in this case.
We did not choose the turf. The claimant said we are not bringing a beneficiary derivative claim. Our claim is a common law corporate claim. They called it a multiple derivative claim, but it's the same thing. So they said, this isn't a beneficiary derivative claim. There's no point us fighting on that territory, because whether or not they should have brought that claim, they didn't, and they disavowed any suggestion that they're the
I suppose another way of putting the same point is that if on the basis of the way in which the claim should have been pursued, the judge had rejected that at the permission stage, and they never pursued it. They never followed up.
Yes.
You could, in fact, at 5-1 before lunch, have sat down and said that's it.
Yes.
The appeal must fail. But that might have been thought to be a rather dangerous course of action, since we spent a day and a half.
If your lordship thinks that would have worked, I'll take it up now.
I mean, I'm only half joking, if you don't mind my saying so, because on one view, that's the answer, isn't it? But given that Mr. Grant has developed all these points, you've got to deal with them.
Yes. The reason we fought on this basis is that's the basis the claim was brought on. It's obviously a very ill-fitting vehicle.
Well, you say that it's, I mean, I'm just making sure that I haven't understood you to be given to, I mean, you're dealing with Mr. Grant's claim as put.
Yes.
Is what I think you're doing at the moment. I mean, at some point I'd like personally to hear whether you say that this is a beneficiary derivative, something which should have been or is in fact a beneficiary derivative claim, but dressed up as a corporate derivative claim for ulterior purposes, to avoid questions such as, are these two claimant beneficiaries truly representative of the fund? You know, which is not a test, you see, which the corporate authorities require you to look into because of the nature of a corporate derivative claim. In the same way as when Mr. Grant was talking about ratification under Section 260. I mean, ratification is so ill-fitting in this case, used in the corporate sense.
Yes.
But it would very much be relevant if this were a beneficiary derivative claim to ask, what do the other beneficiaries of the trust think about the trust's assets being used to fund this sort of litigation?
My lord, I can deal with that head on.
As long as you're going to get to them. I don't want, but otherwise, it seems to me that we're not engaging, at least conceptually, with those problems, which Mr. Grant may have answered, but I'd like to hear from you.
No, my lord, my position is this. This is not this does not satisfy the tests of a common law derivative claim. That's why Mr. Justice Leech found it wasn't a derivative claim, said you're not getting permission, effectively go away. He was correct to do so because it doesn't satisfy those tests. And the claimant's underlying grievance, which could have been brought as an administration action, as a breach of trust direct claim, or as a beneficiary derivative claim, could have been but wasn't. All of those claims have problems, including expressly the difference in the interests of the various members of the scheme. And this was done expressly, in fact, to avoid that problem, the problem of different interests. So it is exactly my submission to say they have tried to crowbar the dispute into this vehicle when it is simply not apt to deal with a dispute. But given that they've done that, I've got to explain why it's not apt and why it fails. But ultimately, they said, we brought this common law derivative company claim. Mr. Justice Leech said, no, you haven't. So he refused them permission. Now, I'll just go on very quickly to Lord Millett. The court's taken to paragraphs 74 and 75, which are at pages, I think page 244 of the bundle, 244 over to 255. And I think the position is this, or that it's said that what Lord Millett says at 74 could be consistent with him saying reflective loss is enough, or reflective loss is a necessity. And in my submission, paragraph 76 does indicate that he thought it was a necessity. And it maybe simply, if I simply ask the court to read paragraph 76, because what I say is that it's clear that the reason they're regarded as having a legitimate and sufficient interest the reason is that he's regarded as having a legitimate sufficient interest, and it's clear from the first part of the paragraph that he has a legitimate and sufficient interest because of the reflective loss.
Now, how do you translate that to the current case? How does that get translated, that analysis, to the current case?
In the current case, there is no reflective loss, either because the company hasn't suffered a loss, whether it's treated as a company alone or the blurring the lines treating it as the fund, or because the loss suffered by the claimants, which is a reduction in their benefits, is entirely inconsistent with the loss they say has been suffered, the wrong that's been done to the company. The people that the claimants think have been damnified are themselves. They say the thing that's gone wrong here is their benefits have been reduced. That's what this litigation is about. That's what they want to remedy. Got nothing to do with the company.
But apparently, as I understand it, Mr. Grant says that the damages which the company would recover, or which will be recovered if he's allowed to pursue the claim and succeeds, won't actually be held for the benefit of the fund anyway.
Yes. That demonstrates the difficulty with trying to crowbar this dispute into this.
In the approach, you would say.
Yes. Now, I'm going to just deal with one other authority, which is Abdel Mahmoud, which is in the composite bundle.
Well, just closing off this point about what we call reflective loss, perhaps inaccurately, what Mr. Justice Richards, as he then was, calls a loss, financial or other loss of the shareholders, albeit normally of a reflective character. That's paragraph 25 of Abu Raya. And he says in terms there that's a requirement.
Yeah.
That's a necessity. And that's what all the cases say.
Yeah.
And as I read it, that passage in his judgment is approved by the Court of Appeal in microfusion.
Yes.
So this whole debate about whether or not it's a requirement is neither here nor there, because we're bound by what this court has said in microfusion.
Yeah, the court's not been invited to depart from microfusion.
No, I'm not sure we could. I mean, the Supreme Court could, I suppose, in an appropriate case.
But if, putting it slightly different way, which I think is the way Mr. Grant puts it, Mr. Grant says, look, my clients or the claimants have suffered loss as beneficiaries under the fund. If, contrary to his argument, a recovery against the directors was held for the fund, why don't his clients have a sufficient interest in the sense of a threshold question or gateway question to bring derivative proceedings? And his argument is they do. I mean, his argument is that his clients do have a do have a sufficient interest, because he says, well, without them bringing the proceedings, the wrong will never be remedied. And I thought it therefore would follow that the remedy would flow through to his clients, therefore they have a sufficient interest. I mean, that is derailed, I think, if the if the recoveries go somewhere else. But if putting that, assume for a minute that the recoveries were held by the trustee company on the terms of the trust for the fund, why wouldn't his clients have a sufficient interest to bring a derivative claim?
If the loss that they were complaining of was consistent with the
Loss to the fund.
to the company, stroke fund, if they're being
Loss to the, yeah.
blurred, then they would. But if they don't,
Yep.
if it's not consistent, then they don't have sufficient interest, or they're not bringing the claim for the good of the
Yeah.
company.
And that, is this right? So that if their loss is I don't use the word reflected.
Yeah.
If their loss
It's concomitant.
is concomitant with a gain by another set of beneficiaries, but the fund overall has suffered no loss, it's just an allocation dispute,
Then it's not for the good of the company.
then there's no derivative claim.
That's right. Well, yes, that in a nutshell, that's what we say there. You have to have the same loss, more or less. I made such a mess of saying concomitant earlier. I'm going to continue to say consistent. Oh, I mean
Sorry.
that. But if you have the same loss, that's fine. You're bringing it on behalf of
So
the company and yourself.
right, so to use another one of Mr. Grant's claims as an example, if in fact the fund has been grievously overcharged for the services rendered to it, such that the fund beneficiaries would have a claim against the trustee company for overcharging it for the services which it had rendered. In a sense, that would, you could see how a beneficiary, if that was the product of some third party or directorial ex-directorial misconduct, then a beneficiary might have a sufficient interest.
If one of the directors runs off with all the money, so that more money has to be called for from the fund, so that benefits are reduced, then there might be a sufficient line. There may be a consistency of economic
Well, that's right.
interest.
Director A basically just steals from the fund.
Yeah.
So, as I think you see in one of the cases we're reading at lunch, director of the trustee company steals from the fund, such that the fund will be unable to pay benefits to pensioners, appropriately.
Well,
and the trust company says, yeah, but he was quite a nice bloke and he was in a bit of a tight fix, so we're not going to pursue him.
yes.
At least there are the makings there of a beneficiary derivative claim.
Yes, and it may even, to avoid some of the unnecessary complexities, if the trustee company has been paid £1 million for next year's expenses, and then a director steals that £1 million, so the trustee company has to ask for another £1 million to pay its expenses and wages and council, then as a result, the fund doesn't have enough money to pay benefits, so the benefits have to be reduced, then you can, there's a straight line there, there's a consistency of interest. If you can get over all the other problems, it's possible. It's simply that's not the situation here.
No.
And I'll seek to develop that when I deal with the...
You were going to show us one more case which wasn't in the core bundle.
Yes, it's Abdel Mahmood. It's in the composite bundle, volume 4, tab 69, page 1061. This was an attempt to bring a derivative claim against a company limited by guarantee, which was also a charity, and permission I think permission was initially refused, but then an appeal by the claimant was allowed. There was further appeal to Court of Appeal, and permission was not given. And paragraph 36, which is at page 1076. Sorry, that's not right. Paragraph 36, which is at page 1070. This is Judgment Lord Justice Newey. Says, and this was a statutory claim. Says, I would find it difficult though.
It arose in a rather odd way, didn't it? It was to do with an application by some members of the company, one of whom was also a director, to set aside the claimant's challenge. And the court said there was no locus in those circumstances.
Yes, it was a very different, actually very
Paragraph
distinct.
36, is it?
But it's paragraph 36 between 1070, 1071. I'll leave the court to read it, but gist of my submissions is there, Court of Appeal said, well, we're not going to find it very difficult to sanction a derivative claim when the Attorney General or the Commission can deal with any misconduct in the company. And we say there's a very close parallel here with the role of TPR, because TPR can deal with, for example, the rates, the discount rates settled upon by the company. The pension schemes under the supervision of TPR, relatively close supervision given the size of the scheme, and that makes it less necessary for there to be any derivative claims. Now the final point I'll make before I turn to the claims themselves is the question of loss arising from the actuarial valuation. For the most part, I'll deal with the facts in relation to the prima facie case point, ground C, but this is so key to the appellant's answers to ground, in relation to ground A, it may be convenient to deal with it now. There is, of course, a question, whose loss, if there's a loss arising from the actuarial valuation. But the prior question, we say, is what loss? Because an actuarial valuation simply doesn't cause a financial loss. The assets are valued, but the day before and the day after, they're the same assets. It's not suggested they're sold as a result of a mistaken valuation, but the assets are the same. The liabilities are the same before and after the valuation. They don't change. All the valuation does, and this is the point of complaint, is to calculate how much money would be required today to pay those liabilities over the years. So it allows decisions to be made about funding in the future, but it neither increases liabilities nor reduces the value of assets. Simply, if you have a very optimistic valuation, it doesn't create a profit or a gain. It doesn't mean you have more assets or that you have fewer liabilities. It simply says that the actuary thinks you only need £10 a day rather than £20 a day to fund the liabilities, which are the same. And it's simply wrong to say that anyone has suffered a loss because of the increased deficit identified by the valuation. And that one way to test it is this: damages aren't claimed directly, although there's a possibility for further or other relief. But it's just worth asking, if damages had been claimed, the selection of the AVR date, actuarial evaluation report date, was so wrong and the discount rate was so low, there was a breach that's caused loss of the £18 billion. Is that the measure of damages? If the deficit is suddenly £18 billion, whereas if more optimistic discount rates have been chosen, there would have been no deficit, is that said to be the measure of loss? And what happens?
So if I can do what I, in fact, didn't manage to do with Mr. Grant, but I kept on hinting we would get there. What do you say about paragraph 83 of the particulars of claim?
The
Give Mr. Grant
is that the one there?
give Mr. Grant a chance to come back and reply. But paragraph 83 of the particulars of claim, which is page 326 of the core bundle.
So I thought this would make things easier. Netflix keeps opening on my
Mr. Short,
iPad.
Mr. Short, paragraph 83 says that the breaches of statutory duty and fiduciary duty have caused the company loss because it constitutes a loss of assets and an increase in scheme deficit identified in the 2020 valuation, and the need to recover that deficit, a loss of revenue as employers, etc.
Yes.
So that is framing a loss to the company rather than the fund, which is another question, in terms of the effect of the deficit, the increased deficit.
Yes.
Whereas I think when I was discussing matters with Mr. Grant, he was accepting that actually what he was complaining about was the change in assumptions, which drove benefit changes, which he said was also caused by having taken a valuation in 2020 when it was unnecessary to do so, and that had reduced benefits. And so he was, I think, despite his pleading, accepting that the ultimate reflective loss, if that was the reduction in his client's benefits. But that's not how it's put at 83.
No, but it is the reality of the case. What I say about 83 is it's just wrong. There is no loss of assets. The increased deficit is not an increase.
You say there are no loss of assets to the scheme, still less to the company.
Yes.
Because the company's assets, as we saw from the accounts,
Remain the same.
One doesn't.
That's not what a valuation does.
No. Well, one simply doesn't get to the question of whose loss it was, because there isn't a loss.
Yes,
So
you say there isn't a loss anyway, but even if there was, it would be the schemes, not the companies.
My lord, that's right. So obviously, if the money is going to be held for the benefit of the company, this £18 billion or whatever it was, whatever the deficit was, then it doesn't really assist the appellants. And if it's not held for the benefit of the company, it's given back to the fund, which would seem fair, bearing in mind it's the fund's deficit, the claim isn't being brought for the benefit of the company anyway. But it's all entirely artificial. There isn't a loss. I am going, in fact, to deal with the particulars of claim.
Before you go on, perhaps we should also, in fairness also to Mr. Grant, paragraph 83 does go on to suggest that all of this will lead in effect to a winding down, a diminution in the scheme, because people won't join and new members won't join, and there'll be a loss of future investment return and other associated consequences.
Yes. I'm not sure that loss of members and employers was pursued because, of course, when members leave, the liabilities leave too. So that will always, if the scheme's working well, that will be neutral in terms of the scheme's position. But Mr. Justice Leech does deal with the consequential impact, and that's in the judgment. I'll come to that in due course. Moving though now onto claim one itself, the starting point, I say, is the helpfully can be taken to be the particulars of the claim, but it's worth looking at the prayer for relief, which is at page 337, the final tab 20 in the core bundle.
Yeah.
And this is what the claimants want, which is in the first hand, declaration that there have been breaches of duties, declarations that there will be loss will have been caused. But C, this is what they really wanted, this is what the claim is brought to achieve. C says an injunction preventing the second or third defendants from taking steps to implement the benefit changes. And that is really, the second and third defendants couldn't do that. That's really an injunction in fact that would prevent the company from implementing those changes. So that is why, in my submission, Mr. Justice Leech was quite correct to accept that this was a remedy being sought against the company, not one for the benefit of the company. And in addition, he was correct to say there was no loss from the valuation to the company. So if there's no loss to the company, this simply isn't a derivative, common law derivative claim. And he was correct to so find, I think that's paragraph 224. No, I'm sorry, page 224 of the bundle, paragraph 131 of the judgment. It's in tab 16. So the question actually asked was, is it a multiple derivative claim? The answer is no. So paragraph 132 though, the judge goes on to say, well, what if the consequential impact, and this deals with the point mentioned by my lady, even if there was a consequential loss, that's not reflective of a loss suffered by the claimants. There, I think it's fairly clear he is using reflective in the sense of consistent rather than as shareholder value. It says, although the benefit changes will lead to a reduction in the claimant's entitlements, it will also lead to a reduction rather than an increase in the liabilities of, he says the company, but really that is the scheme. But in any event, even if it's treated as being a loss to the company, the claimant's loss isn't consistent. It is the opposite. It's absolutely inconsistent. They say they were damnified, not the company. And so Mr. Justice Leech was correct at the bottom of 132. So it follows in my judgment, claimants do not have sufficient interest or standing to bring multiple derivative claim on behalf of the company against the directors. That's really the end of claim 1. Claim 2.
Is that an appropriate moment just to have a quick break?
My lord, yes,
It's a 5-minute break now.
All right.
Emma or
Yeah, yeah.
More of a land at the time.
This is all good. Yeah, we go. Use this places. Yeah, but let's assume that they're not wrong. They want alpha.
Nothing else. Yeah, it's
Thank you. It wasn't freezing, he just kept coming up with Netflix.
It's not the moment.
At least your watch hasn't spoken.
Watch? No, it was the iPad in
Version,
Chris knocked on it. Thanks.
Benson,
Because he nodded.
I think grand. If we think of grand.
All right.
My lord, I was about to turn to claim 2 in the context of round A.
Are you just dealing at this stage with the issue of standing and loss, or what?
Yeah, I'm just going to deal with.
You are going to come back to, because obviously there's a big issue in relation to claim 1 about the allegations of breach of director's duties
No,
and fiduciary duties.
I'll deal with that in due. I'm just dealing now
Okay,
with
okay.
ground 1,
Thank you very
which
much.
is, are these derivative claims? Do
I
the
follow.
claimants have
Thank you
standing?
very much, that's helpful.
Claim 2, I say the position is even more stark if one looks at the prayer for relief, which is at page 337 of tab 20 at the back of the core bundle. And the first thing that's sought is a declaration that the introduction of the benefit changes will constitute discrimination on the part of the first defendant, contrary to sections 1961 of the Equality Act 2010. Pausing there, this is apparently a claim brought for the benefit of the first defendant, in which they're seeking a declaration that the first defendant discriminated against 200,000 people. If granted, we say it would never be granted, it's a hopeless claim, but if granted, that would open up the first defendant to 200,000 claims for injury to feelings. And that really is the end of claim 2. This is not being brought in the interests of the company. It's being brought in the interests of the claimants. Not a criticism, they wanted to maintain their benefits, but they just can't use this as a vehicle to achieve that. There's also a claim for an injunction that makes the same points. What they're really after is a return to the old, maintaining the old benefit regime.
Yeah.
So there's simply no loss to the company has been identified. No loss to the scheme, to the fund has been identified either, because it's a contingency, they say. If a claim has been brought, or if a claim was brought, then the company might be liable. But their way of dealing with that is to stop the changes taking place. Of course, if a claim was brought, it was successful, the effect of the non-discrimination rule would be to return benefits, would be to modify the scheme to return benefits to the old regime. So there would be an additional cost on the scheme. But that's what they're seeking to achieve anyway.
Sorry. My understanding is that the first defendant, the company as an entity, is said to be exposed to discrimination claims. And that's a loss which it's said the first defendant suffers. So if the first defendant was to sue its directors for causing it that loss, why would the recoveries go into this, sorry, did you say that, I thought you said the last bit of it was that the recoveries would go into the scheme?
My lord, I hadn't intended to address that question. I said, no, if discrimination claims were brought,
But they'd be brought against the trustee, wouldn't they?
they'd be brought against the trustee.
Not against the first defendant in its own capacity.
Well, my lord, I'm not so sure that's
Well,
right under the Act. The claim is brought against the trustees.
Yes, the trustee.
But it is also, if an order for payment is made, it will be made against the trustee. Now, it may be able to obtain an order for example, injury to feelings. There'll be a judgment against the trustee. It may be able to get an indemnity from the fund, but the claim will be made against the trustee. Trustee, the company, will be the party in a discrimination claim. But the substance, the effect of the non-discrimination rule would be to modify the
But this is
rules
where
of
I'm curious. If sorry, maybe I've just not made myself clear enough. Okay, if you're right, and the defendant to the Equality Act claim, is the corporate entity, and that the corporate entity is liable for discrimination, then what interest do these claimants have?
Well,
Because unless the corporate entity has a right of indemnity or recourse to the fund, why does it affect these claimants at all?
no, but my lord, on that analysis, it wouldn't, on the assumption that it's a blurring the lines between the company and the fund. It still won't affect these claimants because there's no suggestion, no sensible suggestion that the possible liability to discrimination claims has caused any reduction in benefits. In fact, it's the other way around. The reduction in benefits is said to cause the liability to discrimination claims. But the essence of my submission is what is being sought is to restore the old benefit regime, and that is going to increase the funds, the liabilities of the fund. So if they're relevant at all, they're moving up, right, so that the loss, the risk of the liabilities increasing is different to the loss said to have been experienced by the claimants, which is that their benefits have been reduced. So I'm not trying to say there is a good claim here, I'm trying to do exactly the opposite, but whatever it is, they haven't identified a loss to the company that they are seeking to recover for the benefit of the company. This remedy is expressly sought against the company and would open it up to further litigation. Now, it may not matter in practice because there would be, the company would get an indemnity from the fund should it be made liable, but there can be issues in cases of scheme insolvency, for example, where orders are made against trustees of a scheme that's on its way to but has not got to the PPF. There's been no case on that, but it is an issue that has been raised because the declaration say the rules are changed to say this, but the order for compensation would just be made against the trustee, and that's a limited company.
Mr. Short, did you also say that there is a non-discrimination rule, so in the scheme?
No, my lady.
I misunderstood that.
Yes, it's the non-discrimination rule inserted by section 61,
Yes.
the statutory non-discrimination.
And so therefore, if there were, in this action that's brought by this member X,
Yes.
they would be seeking a declaration that they have been discriminated against, maybe individually or maybe as a representative, who knows, of a class, and they'll be seeking damages for suffering, their damage to their feelings, and they'll be seeking a declaration, presumably, therefore, as I was saying, that the benefit change was discriminatory. The effect of that being under section 61 that it would have to be changed back, reversed in the rules.
Yes, in relation to them.
In relation to them, which would have the effect that no doubt there'd either be more litigation or there'd be a lot of scratching of heads and a change.
Yes, and it would affect everyone. So if someone brings a claim, it's indirect sex discrimination is different because there's no injury to feelings awards, but for historical reasons. But if someone brought a claim and said, I've been discriminated against because I'm young, indirect discrimination because of my age, therefore the scheme is varied in relation to me, and it goes back to the old benefit regime. At that point, there's also a piggyback claim available to someone to say, well, you can't have better benefits for young people than old people, so even though I'm old, I also get the benefit of the old package. So 200,000 people get better benefits and 200,000 people get an injury to feelings claim if they win. Which is why we say this really isn't in the interests of anyone material to this case. It's certainly not in the interests of the company.
Can I try and just say one thing? So if you have a trustee who goes around discriminating against a particular group or groups in the payment of benefit or in some other way, and creates claims for loss, to harm, damage to feelings, I mean, that's introducing a new drain on the fund, if assuming that there's a liability, the liability can be passed on to the fund, isn't it? I mean, if I'm a beneficiary under a trust fund and the pension, the trust creates a raft of claims, which have nothing to do with the policy per se, in the sense that that there is a new monetary liability for hurting somebody's feelings, which is a new liability. Now, either that has to be met by the company as a legal entity out of its own resources, in which case it's no skin off the nose of the beneficiaries of the fund.
Yes.
In which case it's, as I think at the moment, it's impossible to see why beneficiaries of the fund should have a right to start bringing claims on behalf of the company. It's got nothing to do with them. It's really no skin off their nose. But if it is a liability which the trustee company would be able to seek an indemnity for or pass on to the fund, why aren't they interested in that? Because it would diminish the fund.
That's right, but the remedy they have sought is to increase the value of the benefits now, so that will diminish the fund, and that would be the primary remedy in any event.
So you're dealing with this on the remedies inappropriate, as
Yes.
opposed to saying they don't. I thought we were dealing with the question of whether they had an interest.
No, I'm dealing with it in the sense of whether this is a common law derivative claim, and it's not, because it's not brought for the benefit of the company. Because it cannot be for the benefit of the company to get a declaration that the company has discriminated against 200,000 people, and it cannot be for the benefit of the company to order the other remedy that would flow from a discrimination claim to be granted prospectively. So here they're simple.
Well, which could, because you say that the injunction they're seeking, at least in relation to this claim, would have the effect of reversing the benefit changes. So they would obtain via the injunction the same result as would happen at the end of the day if there were,
Yes.
if it were a Section 61
Yes.
scenario.
Yes.
That's the point, is it?
Yes. I mean, obviously time moved on and
No, I understand.
the changes have been introduced by the time of the hearing.
Yeah.
But the claim 2 simply wasn't brought for the benefit
No, okay.
of the company. Claim 3 is one where there is a possibility of identifying a consistent loss, consistent as between the members and company or the fund, as described. And I'm not going to deal with this on the facts, but the question of an alternative remedy in particular arises here, because if the company, if the fund has been plundered, the claimants could bring a claim in their own right to reconstitute the trust's assets.
Sorry, say that again. If the fund
If the fund had been plundered,
plundered, yeah, okay. I thought you said plundered.
so that benefits were at risk, then it would be possible for claimants to bring an action to reconstitute the trust fund, to recover the sums. And therefore, there is an alternative remedy and there is no need for a derivative claim.
Okay, so so if I can put it a different way, if the trustee has overcharged the fund, a beneficiary can say, that's a breach of trust, put it back.
Yes. Yeah, and for that reason, but if the overcharging is through a mechanism of the trustee engaging third-party agents who have overcharged, which it is, as it were, negligently allowed to overcharge, but they're entitled to do it as far as they're concerned. In other words, people are in charge. People are perfectly entitled to ask for outrageous fees if somebody's mug enough to pay them. Yeah.
So, from the third-party advisor's perspective, it asks for an extortionate fee. The trustee, in the hands of its directors, the corporate trustee in the hands of its directors, is mug enough to say, yeah, okay, fine, we don't mind, you're going to charge us this. Well, the third party will be able to keep it. I mean, it's just the marketplace. But the directors have breached their duty to the company as trustee, or they've caused the trustee to agree, qua trustee, to an extortionate fee. Why, in those circumstances, do beneficiaries not have an interest in the trustee pursuing its directors?
Well, if the point is that the trustee has been acting prudently in overpaying for things, the members could bring a claim saying that's a breach of trust, you're spending too much money on other things.
But the problem is that the trustee in this case, as a company, it's not like Lord Adventure, as Mr. Crown put it, it's a company that doesn't have assets of its own, if you like. I mean, it has a limited amount of assets on its balance sheet, but it's not there to make a profit. It's a not-for-profit company. The third-party advisor was perfectly entitled to do what it did.
Yes.
Saw an opportunity, went for it, there's nothing wrong in that, that's the market.
Yes.
The people who did, on this hypothesis, drop the ball would be the directors.
Yes.
Because they allowed this to happen. Now, in those circumstances, why could the beneficiaries of the trust not say the trustee should sue these directors?
If they wanted to do that, they would do that as a beneficiary derivative claim.
Right.
And they would engage with the issue
Right.
of whether the cause of action of the company against the trustee, against the directors, is a trust asset, which is the issue in JAT and MEGS. And if they succeeded on that issue, they'd have a beneficiary derivative claim. That would have been the way to do that particular thing.
Right. But, I mean, you're saying something which, as you may have gathered, interests me.
Yeah.
But you're not saying, as a matter of interest or standing or anything else like it, that the beneficiaries wouldn't have a sufficient interest to see the trustee company vindicate a claim against the directors. It's the procedure is wrong. Is that right?
Yes, I'm saying that on that scenario, there's no loss to the trustee company because it's been no loss for the purposes of common law derivative claim. But putting that to one side, that sort of claim could be pursued in a different way than through a common law corporate derivative claim. And therefore there is an alternative remedy to this remedy, which was the common law company derivative claim. So it didn't need to be done in this way, and this is, as I said earlier, this is an artificial attempt to crowbar it into a different procedural vehicle. And if there is an alternative remedy, and I say there's an alternative remedy to each of these claims.
But if what you're going back to your point earlier, I mean, if what's happened here is that the trustee has overcharged the fund by way of fees and expenses, then the beneficiaries would have a remedy of suing the trustee for breach of trust in that, if it's a sufficiently extreme example.
Yes.
And you know, the trustee might have all sorts of answers to that, like, well, you agreed to pay it, or this is the going rate, or this is what everybody charges in the market.
Yes.
Those are all, as it were, for the future. If you're just looking at what remedies are theoretically available, the remedy of breach of trust would be available.
Yes.
You don't need to sue the directors to do that.
No.
Leave it to the trustee if it wants to sue its own directors later.
And indeed, one can.
But doesn't that assume that, I mean, sorry, but that assumes that the trustee would be good for the company, would be good for the money?
It does in order to.
You know, I mean, it's always.
I follow that.
Yeah, I mean, it's the problem there is, actually, I think on analysis, there may be a remedy, i.e. to a member of the scheme to sue the trustee company for breach of trust.
Yeah.
It may not be worth anything, and therefore the only way in which the injustice would be remedied would be if the trustee company could vindicate a claim against its directors on this hypothesis, or some other entity that had allowed the overcharge to occur. Yes. But then the question is, well, what's the mechanism?
Yes, and that would be a beneficiary's derivative claim, not a company derivative claim.
Although you accept that there might be difficulties about whether what might be recovered would be trust property, or that the duties owed by the trustees are owed under 171 and 172 to the company, and whether any recovery as a result of a conclusion that they are in breach of those directors' duties becomes trust property or remains company property.
Well, that is a complication, but if the answer is it's not trust property, so if you can't bring a
Beneficiary's derivative
beneficiary's
claim.
claim because you can't treat the cause of action as being part of the trust, then this isn't going to help the claimants anyway. Because if it's not trust property, the company keeps the money, any money that's paid back.
But if it's arguably, if it arguably is trust property, because this is a single single scheme trust company.
Yes.
If it's Mr. Justice Lindsay,
Yes.
you know, he did say, in fact, you know, in his case, this is a single
Yes.
scheme trust co. If it is arguable that the proceeds would be held on trust on that claim,
Then it would be a beneficiary's claim and not a company claim.
right? So then your objection to this actually comes down to the process that's been adopted.
Yes. Well, that would be necessary if the company had no assets.
Well,
But there could still be
as I
an
understand it, the essence of this is that the trust company in this current case has no material assets sufficient to, I mean, it's sufficient to discharge the sort of liabilities that might be being spoken about in terms of,
yeah.
you know, I'm not sure it could pay this sort of liability for the overcharge that's allegedly being caused.
The overcharging, when one bears in mind, it's, I think, limited to Mr. Galvin's pay, we'll come on to that.
Okay, we'll come on to
Due
what it
course.
is. but-
It is relatively modest, but this wasn't, the proceedings weren't created in this fashion because it was thought the company did not have enough assets to meet any claims. Certainly in relation to the future, the declarations would have been declarations that could have been sought by the members in direct breach of trust claims. But in any event, these are claims where something else could have been done, it wasn't necessary for there to be a company claim. If that's right, in my submission, if it can be done in another way, it cannot be done in this way. And the authorities talk about no alternative remedy. I note that there is some disagreement as to whether that, or Mr. Justice Lawrence Collins, as he was, said he wasn't sure whether that was a standalone bar or simply that one of the requirements, the requirement of wrongdoer control, wasn't met. But that doesn't, in my submission, matter, because whichever of those it is, if you've got an alternative remedy, you can't do it as a common law derivative claim. And it's wrong in my submission, and a departure from the orthodoxy of the Court of Appeal in Halliwell, in Barrett and Duckett, and in Wallersteiner, to say if you can do it in a different way, you can still bring the claim as a derivative common law claim because there are tactical or cost advantages.
Yeah, I mean, I think you would, sorry, well, let me ask you the question in a different way. Are you a supporter of Mr. Justice Lindsay, or are you a fan of Mr. Justice Miles?
Well, they're both fine judges.
Very tactfully put.
I did appear in front of Mr. Justice Lindsay, so possibly Mr. Justice Miles.
So putting it rather more specifically, I mean, as I read the authorities, Mr. Justice Lindsay in JAP said actually where you've got a single purpose trustee company, it is arguable that the proceeds of any claim would be held on trust for the fund.
Yeah.
I think you, unless I misunderstood you, you would have to endorse that because otherwise it's not an effective alternative remedy.
No, I would say if that's correct, then it is an effective alternative remedy.
But if Mr. Robert Miles QC, sitting as Deputy Judge of the High Court, was right in Gregson, then it wouldn't be an alternative remedy for members of the scheme, which is what these claimants are
That's
seeking to do.
right, but a derivative company claim wouldn't help them either because the money would be held by the company in its own right.
Well, yeah, or in fact, in a sense, if the money would be held by the company in its own right, they've got no interest in the outcome. So in a sense, they genuinely probably don't pass the interest test at the first stage. Okay, got you.
That's
Yeah.
okay. Now, moving on to claim 4, and again, only at this stage dealing with the question of whether it was a derivative claim. The amended particulars of claim deal with this, and this is at tab 20 at page 333, paragraphs 101 onwards. The loss it alleges a loss has been sustained. And it's a claim based on the financial impact of the investments. It's not a claim based on any assertion that there was a duty to sell for ethical reasons. I think the way the claim was put this morning rather trespassed into saying there wasn't enough focus on finance because there was a concern with engagement. So I'm not going to deal with the wealth of authority on climate change cases at this stage. But insofar as it suggested that there was a loss to the company, the evidence was entirely hopeless. It just didn't identify any financial loss that had been sustained.
Why would the company suffer loss anyway?
My lord, yes.
I mean, the company doesn't make any investments at all in anything.
My lord, yes.
I mean, the company doesn't invest in fossil fuels.
No.
In any way, shape or form.
My lord, that's right. But even if one blurs the lines between the company and the fund, which is the only thing you have to do all the way through this claim, even to engage with it on the merits. But on the merits, the evidence didn't show any loss to the fund, to the scheme, from its investments. Although I think the claimants have said, well, this is all a matter for trial and disclosure. They had the top 100 investments.
Well, there's a general plea, paragraph 106, that this has all caused the company loss, and it will continue to suffer loss as a consequence of the director's breaches in this regard. And then if you go on to the declaration sought of Declaration 4B, is that the breaches of course will cause the First Defendant's loss as alleged in paragraph 106. And you say, well, that doesn't amount to a beans because there's no particularisation of what on earth the loss is that the company is alleged to have suffered.
No, there's no attempt to do that. The evidence, there was a report from Imperial College that said a portfolio of fossil fuel shares did much worse over the last 10 years or 20 years than a portfolio of renewable investments. But I can pick good shares looking backwards, but it doesn't show anything about the investments that were held here, still less about the company's position. There were some articles from the Financial Times. I'm not going to suggest they were cherry-picked because they seem to have been chosen at random because they just didn't advance this case at all. It said fossil fuel shares didn't do well during COVID, or at least oil shares didn't do well during COVID because no one was buying oil, no one was travelling. But there's simply no loss identified at all. Irrespective of the next fact, there was certainly no loss to the company and no loss to the members, to the claimants, no consistent reflective loss, because it wasn't suggested that benefit reductions were linked to this. So I'll come back to this in a bit more detail on the merits, but broadly speaking, there was simply no attempt to show that the requirements of a derivative, common law derivative claim were met here. And Mr. Justice Leech was correct to say this wasn't that claim. I'm going to move on now quickly to deal with ground B. This is the personal advantage, personal benefit test. There's, in my submissions, and Paul has had some exchanges with my learned friend, the headline ground of appeal with respect is simply based on a misreading of the judgment. Mr. Justice Leech made quite clear there must be a personal benefit, although in an exceptional case it need not be a financial benefit. Perfectly accurate statement of the law, and it's just been misread.
Do we need to hear anything? Richard? No.
I don't think we need to hear you anymore on that point.
I'm grateful I won't deal with that at all. I think I will make one point though, with the court's permission, in relation to claim 3. Claim 3, certainly as it's been pursued, there's been a suggestion that some of the directors were lining their own pockets.
Well, sorry, in saying I didn't want to hear from you on the point, I thought I meant, my lord meant the question of whether Mr. Justice
As
Leech...
to whether or not financial, but Mr. Justice Leech somehow thought you had to have an element
Yes.
of financial.
Okay.
That's all we were
Yeah, I'm
indicating.
certainly not suggesting you shouldn't address
No,
the way that the case is put, is certainly pleaded at paragraph 106 through to 112.
Yes.
And to engage with the question of the extent to which it actually alleges something which are recognisable as breaches of the director's duties under the Companies Act.
I'm grateful. I will do that. The personal benefits suggested in relation to claims 1 and 2 are set out in the pleadings, paragraph 110, this is page 336, and they are hopeless and have been abandoned, and in my submission really shouldn't have been made. There was a suggestion that the directors appointed, or directors who are also trustees of universities, some of the directors appointed by the employer, have an interest in reducing the potential liabilities of their university to the scheme. That's not been pursued, that's just hopeless. And in fact, the contribution rates didn't change, didn't materially change. I think they went up very marginally in 2020. Pausing there, I should say one thing about this scheme is it's not a balance of cost scheme. Many schemes provide for members to pay X percent, 10%, and the employer has to pay everything else. This is a shared cost scheme, and the default position can be altered by the JNC. The default position is if there's an increase in costs, an increase in funding, that's shared 65-35 between the employers and the members. So an increase in contributions has an impact on members as well as on the employer. 110B is a fairly astonishing suggestion that there was personal benefit, which must mean in a way some kind of improper personal benefit, because it reduced the risk of TPR intervention in the scheme. Pausing there, avoiding TPR intervention really has to be a good thing. And to suggest that there's something funny going on by trying not to have the TPR intervene is ridiculous. And the suggestion that this was done because the directors had an eye on their next appointment was simply hopeless. But these aren't pursued on the appeal, but these are the pleaded allegations. And then finally, Mr. Galvin said something absent context. I'm not going to give evidence about this, but one of the biggest schemes at the moment is the Pension Protection Fund for failed schemes. There have been problems with the delivery of defined benefits over the years. But in any event, none of these matters identify anything that could conceivably be a personal interest of the sort necessary. The way it's put now is that there is a personal interest in ensuring accrued benefits could be paid. And there are two things to say here. One, that's not a personal benefit to the trustees. That's the trustees trying to ensure that accrued benefits can be paid. And that's a separate question I'll address very shortly about whether that is a misunderstanding of their obligations. But even if it is, it isn't. But even if it is, that's not the sort of personal benefit envisaged in the cases. There's no distinction on the appellant's case between why the directors wanted to do something and the personal benefit. They treat wanting to do something for a particular reason as the benefit in itself, and that simply is impossible on the authorities. You must be required to be seeking some other one. You must obtain some other advantage, i.e. release from obligation, effective release from obligations under the contract, as in est manco on behalf of yourself, your political organisation, or something of that nature. Simply saying that you are, the trustee is going to ensure accrued benefits are paid.
But also just in a nutshell, what do you say about the point that it's being said that there's been a preference for accrued benefits?
Well, the primary obligation is to ensure that the benefits promised under the scheme are paid. And the only benefits that have to be paid are accrued benefits. It doesn't mean that a preference was given to benefits that accrued before the 1st of December or the 1st of March. Because new benefits, as soon as time has passed, they're accrued.
They accrue daily.
Yes. And everyone's benefits, once they're earned, have to be paid. And it's the trustee's primary duty to ensure the benefits promised are paid. And I think the focus is on the word already. But that, in my submission, that's not about saying it's only benefits accrued before the 1st of March to 2020 that were relevant, because the scheme simply doesn't work like that anyway. Either it can afford to pay its benefits or it can't. And that's all that was done here. Section 222, I'm not sure we need to go to it, does focus on transition, your technical provisions, how much you need today for your obligations today. But the reality is, the only thing that the trustees can do is ensure that there's enough money coming in to pay for everything. And they can do that either by modifying the contribution rates. In fact, that's the only thing the trustees can do. And if the rates were going to increase so that they became unpalatable, the JNC could say, well, we think you should amend the scheme benefit. And then the trustee has to go along with that, save in particular circumstances. But there was no misdirection in law or no failure to appreciate their obligations. The trustee had to make sure benefits accrued under the scheme were paid, and that's what it's sought to do. And even if they got the law wrong, they didn't in my submission, but even if they did, there's no personal benefit. I'm not going to deal with claim 2 separately because it follows on, as I understand it, from...
You haven't explicitly dealt with 108 and 109, you dealt with 110. What do you say about 108 and 109? I mean,
But this was 108. All of these paragraphs were introduced by amendment, possibly once it was recognised that these were common law claims that needed to show some personal benefit. That's what they added. And the suggestion can be broken down.
And they actually got permission to make these amendments.
No, although because the claim form hadn't been served, certainly we took the view that they wouldn't have needed permission. So there was no issue.
it's like a sort of reverse strikeout. I mean, you see the best case, shows your best case, and if you get a chance to...
There was no issue.
But I mean, as I read this, they're saying that the directors had the aim of reducing future defined benefit accrual in the scheme, and the only rational explanation for that is that they had some personal interest or benefit.
Yeah.
At the moment, I mean, I don't personally understand the connection between the two.
No, I think that was in part related to paragraph 110 when it said, well, some of these people are appointed by universities, so obviously they want to suppress it.
So you read 110 as being simply the elaboration or the particularisation of the allegations in 108 and 109.
Yes, but also
Okay.
the suggestion that's made in 108 is what was done in relation to the AVR, the effective date of the AVR, and the discount rates that were selected were so inexplicable. It was to be inferred that it was being done for nefarious reasons. We said that is a ridiculous suggestion because, if nothing else, there have been many documents explaining exactly why we did this, transparent to the scheme. So not all of the documents were publicly available that were before Mr. Justice Leech, but many of them were. Many of them are addressed or available to the membership. And so the suggestion...
And they'd had actuarial and legal advice over all this.
But they've had legal advice. The employers have had actuarial advice. I don't know if the claimants themselves had actuarial.
No, I mean the scheme.
Oh yes.
Throughout is being advised by actuaries and lawyers.
Yes. I mean, I'll come back.
So it's not as if you know, if there was something nefarious going on, one might have expected your instructing solicitor to have picked it up.
Yeah, someone would have
to have said, "Hang on a moment, why are you doing this?
Yeah.
This isn't in the best interest of the scheme. You shouldn't be doing it."
And I'll come back in some detail, not a lot of detail.
Well, you know, that meeting of the JNC, you put in proper pressure on them you forced them to do something.
Yeah.
I mean, one thing I didn't follow in 109. It says the only rational reason why the directors would want to project a large deficit in the scheme, ignoring substantial subsequent increases in the scheme assets. So I think that means ignoring the possibility that there might be substantial increases in the scheme assets in the future.
My lord, I don't think that's right. I think their consistent case was that the trustee and the directors had ignored the bounce back in share values in 2020. That's just unsustainable. And I will perhaps tomorrow go through a couple of the documents which make absolutely clear the trustees kept saying, the appellants have just ignored this, but kept saying, we've run the figures from March 2021 as well, and the position's a little bit worse, because although the assets have bounced back, one of the other things is that future improvements are less likely to take place. So the rate for funding future benefits has gone up. So the deficit repair contributions come down, future funding goes up, overall in a slightly worse place. The appellants have never said that that's wrong, they've just ignored it. So with all these things, absolutely obvious and clear explanations were given, which are just ignored. Of course, if you ignore the explanation for things, those things are inexplicable.
We can see a number of the documents we were shown this morning. Mr. Grant read us gobbets, if I can put it that way.
Yes.
But when you actually looked at the rest of the document, you could see proper explanations provided for what was going on.
Yes. So the premise at 109 is not accepted. I think, in fact, this morning my learned friend accepted or said he didn't suggest that the choice of the effective date of the valuation or the discount rate were decisions that no reasonable body of trustees could take.
Made in bad faith or anything.
Made in bad faith. Now that probably explains why they didn't bring this as an administration action, because also really makes difficult the idea that on the merits there's a breach of trust claim. But we don't accept the suggestion that it was perverse, and the suggestion that the only rational reason why the directors would want to project a large deficit in the scheme was to force JNC to cut terms on which benefits would be accrued in future. It's based on a false premise. It's just nonsense. And it's a really serious allegation. It looked like an allegation of bad faith.
Well, it's because it is an allegation of bad faith.
The appellants have rowed back from that today. But really serious allegations of this nature, it shouldn't be made as lightly as they have been made. And even if there was merit in anything, any of the other claims, the fact that the appellants were willing to make such allegations without any basis would call into question whether they would be appropriate derivative claimants in any event, because this really shouldn't be done. Now, I'm really going to repeat those submissions in relation to claim 3, because this certainly has been pursued as something close to an allegation that they were lying in their own pockets, really shouldn't be made without being very clearly set out. There's a bit of a disagreement here. The judge, this is I won't go to the paragraphs, Mr. Justice Leech, paragraphs 178, 179, page 242, the core bundle. Actually, perhaps I will ask the court to look at paragraphs. Paragraph 178, page 242.
Page 178.
I'm sorry,
242.
paragraph 178, page 242, my lord. And paragraph 178 finishes off with the claimants do not allege the directors or Mr. Galvin used their control over the company to confer benefits on themselves through increased fees or salaries, this kind of conduct which engages the fourth exception. As I understand it, my learned friend takes issue with that, says that was the thrust of the case. Certainly not the thrust of the pleadings, because if one goes back to 336 and looks at paragraph 111, particularly the parentheses, Mr. Galvin is said to enjoy improvements to his remuneration, but that's not said in relation to the directors, the other directors. Of course, the budget for directors' pay is all subject to the JNC in any event, but pursuing this allegation as if people lie in their own pockets is really something that should only be made with some clear, first it should be pleaded clearly, and there should be some good evidence for this. Mr. Gibbs' evidence, which is, I'm not going to go to, but for the court's note at Supplementary Bundle 1, tab 3, page 33, paragraphs 30 onwards, deals with the arrangements and how pay is set. And it's an allegation that shouldn't have been pursued. I think I can deal with claim 4 in a moment, in a short moment before past. The suggestion at claim 4 is that they furthered their own interests by putting their own beliefs with regard to fossil fuels above the interests of the beneficiaries and the company. This was based on, as it was developed, this is dealt with by Mr. Justice Leech, tab 16, page 247, and that's paragraph 193.
Yeah.
So they pleaded that some of the directors put their own beliefs above the interests of the beneficiaries of the company. However, Dr. Davis asserts in evidence some of the directors have acted to avoid the risk that they might risk future directorships in other organisations. Different allegations, not satisfied there's any evidence to support either of them. That's an unimpeachable finding. There was just no evidence to suggest these were decisions because the directors were seeking to put their own ethics, whatever that means, above those of the members. This was based on two things. First was that some of the directors had worked for either British Coal or JP Morgan in the past. And that's simply a ridiculous allegation, because someone has done that in the past, they can't be trusted with other people's money because they will spend it to further their own ethics. Ironically, one of the areas where the trustee had excluded investment and divested was thermal coal production, i.e. digging coal to burn for electricity, on the basis that you can't engage meaningfully with a company that digs coal to burn it, because that's what they do. And of course some people who worked in finance, because people who look after assets tend to have worked in finance. The other point they make is the survey to which court was taken this morning. This is in Supplementary Bundle 2. And and at tab 36, and I hesitate to disagree with my Lord the Chancellor, but if one looks at page 335, I'm sorry, it's a supplemental bundle, this is the last point I'll make, 335, and that's tab 36. Yeah. And although they did get 4,000 responses, in fact, they only analysed 2,000 of them. Only 2,000 were linked to admin data for further analysis. So it's not 1% of the membership, it's 0.5% of the membership was surveyed, and 60%.
60% of
Half.
0.5%.
And they're self-selecting. That's not no criticism of them, but people who have very strong views
They're going to answer.
will self-select to respond. So this doesn't show us anything. And unless I can assist further, they are my submissions on ground B, which is the personal benefit. Each of those claims was hopeless, failed to show any personal benefit. What I propose to do tomorrow is to deal with ground C, which deals with the merits, as it were, prima facie test, and then shortly to deal with the question of discretion. But I am optimistic of allowing my learned friend an hour, 30 minutes at least, and hopefully an hour for his reply.
Jolly good. Well, 10 o'clock then.
My lord, yes, if we sit
Yeah,
at 10.
we'll start at 10 o'clock tomorrow then. Thank you very much.
All right.